national security aid package for Ukraine, Israel, and other U.S. allies closer to passage. House Speaker Mike Johnson says it is a product of a divided government and therefore imperfect.
This is the best possible product that we can get under these circumstances to take care of these really important obligations.
Opposition from GOP Texas Congressman Chip Roy concerned the bill does not address national security at the southern border.
Speaker Johnson said in January, if President Biden wants a supplemental spending bill focused on national security, it better begin with defending America's national security. We want to get the border closed and secured first. To that, I say amen. And where is that, Speaker Johnson?
The final Senate vote on the package expected today. Cliff May with the Foundation for the Defense of Democracies says there's a fundamental flaw with the president's approach to foreign aggression, and it's exposed every time. He says the U.S. does not want to escalate tensions.
There is a real problem with the U.S. and really with the West in general of not wanting to win wars, of not thinking war should be won, of not using words like victory for us or defeat for our enemies.
The Senate dismissed all impeachment charges against Homeland Security Secretary Alejandro Mayorkas, ending the House Republican push to remove the cabinet secretary from office. On the Salem News program this week on the Hill, House Majority Leader Steve Scalise says Mayorkas should have been tried for his handling of the U.S.-Mexico border.
He should have been able to present his case. If he's really innocent, then he would have presented his case and proven his innocence. But he couldn't do that. So Schumer used some of his henchmen to literally just discard this. And the American people are disgusted by it because they want a secure border. The country deserves a secure border.
The interview with the House Majority Leader will be heard on This Week on the Hill on many of these stations. This is SRN News.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Good morning, everyone. Wow, he wasn't kidding. That volume is really up today. The new system is a cracking. Hi, everyone. Welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. We are live, and today is Saturday, April 20th, and we will be with you for the next hour to answer all of your legal questions. The law office is open studio lines. Give us a call now with all your legal inquiries. We'll do the very best we can live over there. Action-packed show lined up for you. 877-943-9673 to get in the queue and get screened. We'd love to talk to you. 877-943-9673. A few preliminary housekeeping items before we turn to our main topic for today's show. A very special thank you to a cat named Mo for having me on his show yesterday while he was covering for Mr. Drew Garabo and John Sinning, and I had the pleasure of hanging out and listening to three original songs by a young lady by the name of Miss Kendra Morris, who, for those of you who have the opportunity this evening in St. Pete at Daddy Cool Records, she will be performing live, a free concert for those of you who want to come out and support Kendra, an absolutely amazing artist, and felt very blessed to hear her do 3 live songs in studio yesterday. So check that out at Daddy Cool Records, St. Pete, tonight at 6 p.m. Also, and a very special thank you to Mo DeWitt. And we had a fantastic dinner last night with cat named Mo, and Spike was there as well. So thank you also to Frankie's Chop House. Absolutely amazing experience. For those of you who haven't been to Frankie's Chop House, I want to encourage you to get over there and give it a try. It's absolutely exceptional. I recommend the cowboy ribeye. That's what I had last night, and off the charts good. So I recommend you check that out. And a very special thank you to our waiter, Terry, who was just so nice. And at the end of the night, he came over and just wanted to say thank you to us for being on the radio. And just, it was such a heartfelt thank you about, thank you guys for what you do when we're driving in home from work. You guys give us something to sort of take our minds off everything. And Terry, we appreciate you coming over and saying thank you for that. And the service was excellent, so we appreciate you for that as well. In other announcement news, today is also Taste of Indian Rocks Beach at Chickasee Park. For those of you in the Indian Rocks Beach area, that'll be going on from 3 to 9 p.m. So for those of you Indian Rocks Beach bound today, from 3 to 9, you may want to check out Chickasee Park for the Taste of IRB Festival. To be part of today's show, 877-943-9673. Today's show, for those of you who tuned in last week, you know what we're talking about today. We are doing our next segment in the Estate Planning Around the Nation feature, and today we turn our attention to the Keystone State. We're going to be talking about the laws of the Commonwealth of Pennsylvania. Before we introduce our guest, some interesting facts about Pennsylvania. Did you know that Pennsylvania is the first home of the first baseball stadium, which was built in Pittsburgh in 1909? I'm a big baseball fan, so I really appreciated that fact. The chocolate capital of the United States is in Hershey, Pennsylvania. I think that's no surprise. Now this one surprised me. The first computer existed in Philadelphia in 1946. So sort of around that World War II era, which is fascinating. The first piano in America was built in Philadelphia in 1775. This one I think we all know. The Declaration of Independence was signed in Philadelphia in 1776. The Philadelphia Zoo was the first public zoo in the United States. And Philadelphia was once the capital of the United States. First daily newspaper was published in 1784 in Philadelphia. So lots of great first and prominent significance to the great Commonwealth of Pennsylvania, not the least of which is our guest joining us today, a very proud graduate of Widener University, and with her BS degree, and a graduate of Villanova School of Law. Our guest will be none other than Miss Stephanie Kalogridis, who concentrates her practice in estate planning, estate and trust administration, wealth transfer, succession planning at Lamb McErlane in Westchester, Pennsylvania. Stephanie has assisted her clients find personalized solutions to meet their estate planning goals through the use of wills, trust, gifting, and legal agreements. Pre- and post-marital agreements, cohabitation agreements, and trust are often utilized to effectuate planning goals, as well as matters unique to non-traditional families. So joining us now, my friend and your soon-to-be favorite attorney from the Commonwealth of Pennsylvania, Miss Stephanie Kalogridis. Stephanie, welcome to the show.
Good morning, Patrick. I'm talking to you from kind of overcast Pennsylvania. I hope it's sunny down there in Florida.
It's gorgeous outside the studio today. Actually, I put the car in auto drive so I could take some pictures coming across the bridge because the sunrise was just so majestic and breathtaking. And it's just one of those sunrises, Stephanie, where you look at it and you're like, how can people think all this happened by accident? And there's not some divine architect behind all of it. So no, gorgeous here. What's the temperature up there in Pennsylvania today?
It's going to be low 60s. It's kind of, like I said, it's kind of drizzly. It's not great.
That's cold.
But we're a big state. And I'm sure that there are places in Pennsylvania that it's absolutely glorious. So
in doing some research this week, you're not kidding about it being a big state, it's kind of like Texas big in a way, because people think, oh, I'm in Dallas, I'll run over to Houston. It's like, I'm in Philly, I'll run over to Pittsburgh. Yeah, I'm going to make a 5-hour drive. Like, it is a massive state.
There's a big divide. You have your Philly based and you have your Pittsburgh based, and Pittsburgh teams, fans don't like the Philly fans, and the Philly fans don't like the Pittsburgh teams.
So that's one of the facts that I left off. I didn't want to read the entire list. Also, I just hate reading copy. I think it makes for a lot of boring radio. So I try to keep it to a minimum. But one I didn't get to was for one season in 1943, the Philadelphia Eagles and the Pittsburgh Steelers merged. Did you know that?
No.
And
for my time.
Well, I presumed that. It's probably before your parents' time. But they actually became the Steagles. And this was due to World War II and the loss of so many players in the war effort. So I found that interesting. Like, my gosh, how do two rival teams put their differences aside and sort of, come together? But I guess in the name of World War II, patriotism being a lot higher, I guess nothing brings a nation together like war. It's unfortunate that that's the case, and we can't be more unified without a war. But yeah, exactly. So, Stephanie, we appreciate you making the time to be part of this segment. We're just trying to help a lot of people understand some of the differences between Florida law and all the different states, because we have people who sort of straddle different state lines. And this was a segment idea that came to me when I was broadcasting from New York City. and we've done New York, Massachusetts. This is the third state we're covering, and we're honored to have you be part of the show. Anything I left out in your bio that you want to sort of hit on?
No, just the fact that this is the area that I concentrate. I mean, I would say 90%, 95% of my practice really is on estate planning. And I think that really helps because I get to see a lot of different situations and a lot of different family situations and solutions. And I think it brings allows me to bring a lot to the table when I meet with my clients because I'm not a cookie cutter lawyer. I'm not going to pull out a document from a form book and say, oh, you fit form, 104, and somebody else's form 102. Everybody's situation is unique. And I like to take my time to find out what the real family story is behind things.
And
Make things go smoother.
There you go. I couldn't agree more. Robert, I see you on the call line. We're going to get to you in just a moment. If you have a question for Stephanie or me, 877-943-9673. For those of you just joining us, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Joining us on the line for our Estate Planning Around the Nation segment is Attorney Stephanie Kalogridis, who is a practicing estate planning attorney from the Commonwealth of Pennsylvania. She's here to answer all of your Pennsylvania related matters. And I know there's lots of people, because I had them in the office this week. They said, oh my gosh, I'll definitely be tuning in to listen to the show because they are snowbirding between Pennsylvania and Florida and kind of wanted to know the comparison and contrast. Stephanie, before we get into that, I was trying to remember, how did we meet? Did I refer a case to you or did you refer a case to me? I don't remember. It's been so long.
Well, I was on an airplane flying to Europe, to London, and I was sitting across the aisle from a person who asked me what I did for a living, and we started talking about wills and trust, and he starts telling me about this case that his wife was involved with, and some of the issues that they were having, and all of a sudden it just started to ring a bell. And it was a case where you representing the other side.
Small world. So you were sitting next to someone and you were, oh my gosh.
Yes, and we were just talking in general and wills and trusts and estate planning. Oh, I don't remember if it was a mother or father-in-law, died recently, and my wife is her sister, and da-da-da-da, and, it was, like I said, and all of a sudden I sort of had worked with you or had read things from you. I don't remember exactly where we were in the process. I don't think we had negotiated anything or anything. But like I said, all of a sudden the fact pattern started, falling in place. And I said, you know what? I said, your wife's first name doesn't happen to be Susan. I don't know what it was, Susan. And he goes, yes. Susan, Susan such and such? Yes. And I said, I really can't talk to you about this anymore. And that's what it was, because she must have been your client, is what I'm thinking. The wife was your client.
That is just such a small world.
I would represent her sister, Mabel. You probably got a letter from me recently. I think I sent a letter out to the sister or two, so it was kind of funny. Very small world.
He didn't try to get up and move seats or anything, did he?
No.
Okay, so you had some neutral zone there.
Actually, he wanted to know if I could represent him because he was working with somebody else, not you at the time, somebody else, and he said, can you represent me? I said, no, I can't represent you. In that other matter.
That's funny. But, listen, and that's a good example. So attorneys often wind up on opposite sides of the cases, but still maintain an amicable and friendly relationship after the case. And like you and I, we've referred cases numerous times to each other over the years. So it doesn't everyone think it has to be this sort of knockdown, drag out fight where everyone gets really hurt and angry at the end because we're on opposing sides. And that's just not how the real world should work. And I think this is a good example of that. So Stephanie, thank you for refreshing my recollection on that.
No problem. The other thing, Patrick, on that note is the fact that, I am always happy when the opposing counsel is a knowledgeable estate attorney.
Right.
Because when I say to them that they say, well, and I say, you can't do that because of X, Y, Z, they understand that the law doesn't permit you to do that.
Right.
You're going outside of that. Whereas sometimes if you're dealing with somebody who's not as familiar on a day-to-day basis with the field, a specific field, they may think you can do something differently, and it becomes more difficult. So I'd much rather have a knowledgeable attorney on the other side.
Well, that's, I was just going to say, so a lot of times, you're representing a client like a PR or a trustee on an estate administration, and one of the beneficiaries, sends correspondence saying, well, maybe I should go from being pro se to hiring an attorney. And they say it like it's a threat to you. And it's like, no, you hiring an attorney is probably going to make my job infinitely easier. And I think that's a common misunderstanding, that people think, it's a threat to an attorney when you threaten to go and hire your own attorney. No. If the two attorneys can talk A to A, and things go a lot more smoothly and quietly into the night, because there's not this need to sort of educate, because you have the attorney on your side educating you that and trust, because it's your attorney, and you sort of have this implicit trust as opposed to like an implicit suspicion because it's the attorney for the other party.
Other side. Absolutely.
Yeah.
Absolutely.
All right. So Stephanie, let's start with our first point. What makes a valid will? So in Florida, a valid will is made if it's signed by the testator or testatrix at the end of the document in the presence of two witnesses. That is the standard for a basic non-self-proving will. Of course, there's additional standards to have the will be self-proving, the affidavit language, and notary, in addition to the two witnesses. Maybe let's just start with that distinction between Florida and Pennsylvania.
But Pennsylvania, there are a lot of things that can constitute a will. Pennsylvania is a very low hurdle. It has to have what they call testamentary intent, when I die. So it can't be, hey, Joe, I'll give you my car. That doesn't have testamentary intent. So it has to say, Joe, when I die, I'll give you my car. It can be in writing. It can be on a piece of paper. It can be, we have a case where somebody wrote a will in lipstick on a wall.
Mm-hmm.
When I die, I leave my car to Mary. Signed, Bob. That became a will. So it had the testamentary intent when I die, and it has to be signed at the end. It doesn't need to be witnessed. It doesn't need to be dated. It doesn't need to be notarized. All those things make it easier when we have to admit a will to probate, but it doesn't make it any less valid. Dating it helps us decide, is this the most recent will and therefore it controls, or is it the other one that they produce more recent? So that's why you like to date it. Witnesses shift the burden. It says, somebody has a will and it's been witnessed. Well, that means that the other person has to prove that it really wasn't done properly. So all these other things, the witnesses, we have self-proving affidavits as well, which are notarized and signed by witnesses and the testator. We have those too. They just make it easier for the basic will. Donative intent, testamentary intent, signed at the end. But that signed at the end is a very, very strict element.
So that reminds me of sort of the lower standard that I remember from law school when I was in law school at North Carolina at UNC Chapel Hill, where, for a holographic will, it could be admitted there if it was entirely in the testator or testatrix's handwriting, entirely. So it wasn't like a template that they had filled in and signed. And because of that, I sort of have two follow-up questions. So number one, in North Carolina, that's the reason why there are bathroom stall doors that have been stamped for probate at the clerk's office. So I was going to ask you, that case where it was lipstick written on the wall, did they take a jigsaw and jigsaw out that section of the wall and stamp it for probate, or how did they?
They did.
Okay, yeah,
They did. They cut the wall out of the house, and they took it to the Register of Wills office in Philadelphia. It was a Philadelphia case, and it was sitting down in the archives for the longest time. Yep.
So what if I had a very good fraternity brother, and I'm just throwing out a hypothetical, and I, in my own hand, tattooed my will in the Commonwealth of Pennsylvania onto his forearm? I pass away. Do they have to amputate his forearm and admit it to probate?
No, we would, if that were the situation that came through the door to me, we would file a motion to have a copy of the will admitted.
That's so not exciting here, Stephanie. I was so hoping you'd say that he's going to lose an arm. It's going to be unfortunate. It's a very, very disarming case.
Yeah. So mad.
Okay.
For 8 o'clock or 7 o'clock, 8 o'clock in the morning. No, we would try to work around it. And so, and I think that wall case was a very old case as well. We would have a hearing. We would probably bring the person in who has it tattooed on his arm so that the clerk of Register of Wills would be able to physically see it. But if you're admitting the copy, then all the intestate heirs surely would have the right to contest and
Right.
come into the thing. I would think the highest standard on that one is going to prove the signature.
Yeah.
He would have had to have been the tattoo artist.
That's what I'm saying. I
It's just-
tattoo it myself onto, or if you take a Sharpie and you write it on an elephant, do they just bring the
Mhm.
elephant into the courtroom? I mean, it would be one of those things where I can just think of so many fact patterns where, like, for instance, if you write it in like erasable marker on the side of a car, like you have to act quickly to preserve that because, one rain shower, that's gone. And I'm just thinking of all these different scenarios where that's going to be particularly trying as a matter of public policy to preserve those instruments that are written in non-traditional places.
Well, we do have a procedure, like I said, to admit a copy. Many times, so a client comes to the office, we sign our documents. We offer to hold the original documents in our safety file so that they don't get lost. But let's say a client took it home. The presumption is if it was in the testator's possession and you can't find it, the first presumption is that they destroyed it.
Yeah, same in Florida.
They have to get over that hurdle. So let's say nobody's really contesting it. You have a whole, everybody is fine with the testamentary plan in the document.
Mhm.
Then we have a procedure where we can admit a copy because I happen to, while I gave away the original, I kept a copy of it in my file electronically or whatever. You have to show, like I said, you have to get over the fact that whether he destroyed it or not. But you can admit a copy, and you just, it goes easily if you have everybody, all the intestate heirs and everyone named in the will. If everybody's in agreement and you put affidavits with your petition, it can go through relatively smoothly.
Well,
But what it does, those are things that open it up to attack.
Well, and I
If
was going to
something
say,
doesn't
we've got a
happen.
case here we can discuss in a moment that kind of demonstrates the importance of printing out a hard copy of a will versus trying to get a copy admitted. But before we do, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, joined by Attorney Stephanie Kalagridis from the Commonwealth of Pennsylvania. We're answering all of your Florida and Pennsylvania laws questions today. So give us a call now if you have a question. We will be happy to get you screened and on the air. 877-943-9673. That's your live and local studio line. Let's go to a very patient Robert in Haines City. Robert, welcome to the Attorney Patrick Smith Show.
Yes, sir.
How's Haines City
Good morning.
this morning, Robert?
It's nice
Morning,
and
Robert.
sunny down here.
Say
Good morning,
hi,
ma'am.
yeah. Say hi to Stephanie. I'm from Polk County, Robert. You know that, right?
Yes, I do, sir.
All right. Well, how can we help you today?
Well, in Polk County, there's a couple of different platted sections of land that are in lots, and we're looking at purchasing a lot or a couple lots in these land areas. But we've run across the situation where all these lots are the same, and they equally had the same easements and the same wording on the deeds. But now we've run across some properties that have been purchased through the years by taxes, and on the tax deeds there's some writing that's left off about some easements. And I was just checking to see, is that the situation where now the new tax deed is all there is, or do you go back to the original wording and pick up those, able to pick up those easements?
Well, I think it's one of those specific situations where we're going to have to do a title search and search the records. And it possibly, Robert, could end in something called a quiet title action, where you basically have to get this issue settled in a ruling from a court. And Stephanie, would that be pretty much the same in Pennsylvania if that was an issue?
Yeah, I would think so, because you need to determine whether those easements survived.
Yeah. So, I mean, the ultimate example of something like this, Robert, was actually going back to Katrina, where what happened there was they actually had paper deed records, and the courthouse lost them all when it flooded there, and they had to go back and recreate everything. And it was a famous news article that came out about it because one of the attorneys attempting to do that for his client took it all the way back. I don't know, it was like 17 something or 18 something. And they sent a letter to the U.S. Secretary of State's office and said, look, we've done it all the way back to here. We need your assistance in getting the clear title. And the U.S. Secretary of State's office supposedly responded by saying, no, you need to go back further. You haven't gone back far enough. And the attorney's response was, well, we can't go back any further because you see, I took it back to the Louisiana Purchase. So if you want to go back any further, you're going to need to ask France about this. And I always found that kind of fascinating and made me chuckle a little bit. But yeah, it's probably going to be at least a title search. If you need a title company, I can put you in touch with one to kind of give you a search of it. They'll point out any title issues that you have, if any. And once we've identified the issues, then we can identify how to remedy those. Not the end of the world, Robert. It's a fixable solution, a fixable situation for sure.
Okay, so it's just the point of if they survive through the tax deed process, then
I think
that's what you're going back to look for.
I think that's exactly what you're looking for. And basically what someone purchased as a good faith purchaser for value and how that affected the property. I think it's just a matter of just getting a clouded title cleared up.
Okay. I appreciate it, sir, and I appreciate your program. Thank
Robert,
you.
I appreciate your kind words. Thank you. Take care of Polk County for me, okay?
Okay, sir.
All right,
Thank you.
bye-bye.
Bye-bye.
All right, 877-943-9673, 877-943-9673. Before we talk about that e-will case out of Pennsylvania, you want to take a couple more calls, Stephanie?
Sure, why not?
All right, let's go to Steve in Venice. Steve, welcome to the Attorney Patrick Smith Show. How are you today, Steve?
I'm great. I'm in autopilot, Patrick. I just rolled one and I'm cooking it down. I wanted to wish you a happy 420.
Well, I appreciate you celebrating. I will not, Steve, but what's your question on finances?
My question on finances is I'm refinancing my house and I've never done anything related to a will.
Hey, Steve,
I don't
think
know
you're-
that much
I think
money
you're
on the
getting,
house.
Steve, I think you're getting pulled over. You may want to just look behind you real quick.
No, it's an ambulance.
Okay, all right,
Somebody
good.
already
So-
cooked down too much.
Okay, all right, Steve, go ahead.
No, I don't know very much on my house, and I want to refinance and set things up so I don't have to deal with things if something happens. And I don't even know where to start.
Well, I think with something like that, I think you start with a financial advisor. If you want me to point you in the right direction, I've got some that I work with down in that Venice area. I'm happy to point you in their direction. And they can set you up with a free meeting, kind of tell you what they can do to help you with that plan. From the legal side, of course, if you don't have an attorney, I'm happy to jump in and assist with you. But it's really that.
I don't have any of that.
Yeah, we can help with the estate planning side. We'll put you in touch with a good financial advisor. And I also think you need a good CPA. And it's sort of that, no disrespect to the actual Trinity, but it's sort of that trinity of financial professionals, the attorney, the CPA, and the financial advisor that sort of maximizes your protection now and for your family when you're gone.
What do I got to do? Get an email, or how do we do that?
I'll give out. So when it's safe, and you can always Google me, I'm pretty easy to find. And I'll give out the office line here a couple of times during the show, because if I don't, people will get very angry. And so, Steve, when we hang up, I'll give out that office line, and you be safe out there. Okay, Steve?
Oh, I'm great. Someone else is driving.
Okay, you said you put it in autopilot. Are you driving a Tesla, or do you have a...
No, I have a girlfriend who drives when I roll. I'm not rich like you. Come on, dude.
Steve, be safe. Have fun with your girlfriend, okay?
I always do.
All righty,
Take
man.
it.
Have a great day. 877-943-9673. 877-943-9673. Give us a call now, live and local. Happy to answer any and all of your legal questions. That did open up a line. So if you're trying to get through, I know the lines have been jammed, but keep trying. We will get you on the air. 877-943-9673. You can always email your questions too. I don't always get to the email part, but you can email me, Patrick@attorneypatricksmith.com. Patrick@attorneypatricksmith.com. I'm going to jump to Mike. I'm going to get to you in a second, but I'm going to jump to Henry, because Henry actually has a question for you, Stephanie. So I'm going to jump to Port Charlotte. Let's talk to Henry. Henry, what's your question for Stephanie?
Good morning. How are y'all doing this morning?
Great.
Hey,
Yes.
Go ahead, Henry.
I am a Florida resident, and we have property here that we hold in trust in Florida. We recently purchased property in Pennsylvania, and my question is, can I have that Pennsylvania property, roll into my trust down here in Florida?
Stephanie, the floor is yours.
Okay. Yeah, that's an absolutely fantastic question that you're asking right now. So there's two aspects of it. So when a person is domiciled, lives in one state, and owns real estate in a different state, when they pass away, that real estate in that other jurisdiction, not where they're living, you have to have both probate in your home state, and you would have to have probate in the ancillary, so in Pennsylvania. So your state would have to deal with the Florida matters primarily, but you still have this Pennsylvania property. So by putting it into a revocable living trust, I know you guys love those down in Florida.
Yes,
By
ma'am.
putting it in there, you will be able to avoid the probate system of Pennsylvania and having to deal with it through that court system. What that will not do, Pennsylvania is one of the few states that still has an inheritance tax. So when the property passes at your death, it will be subject to Pennsylvania inheritance tax, whether or not it's in your name alone or if it's in your revocable trust. So, so again, it would help with probating, but it will not help to relieve the Pennsylvania inheritance tax on that property.
Stephanie, I have no notes. Henry, that was a perfect answer. Did that cover it for you?
Yeah, I think so. Is there a lower limit when the tax comes in, the inheritance tax comes in, or is it from dollar zero?
So it's basically from $0. You would be allowed, as an out-of-state resident, you'd have a very minimum amount of deductions that you could take against that possibly. There's a lot of things that go into whether or not you can use any deductions. But it's basically from $1. Now, if it's going to a spouse, we have a flat rate of 0%. It's a tax. You have to file a return, but the tax rate is 0. If you are going to children, the tax rate is 4.5%. If it goes to siblings, it's 12. Charities are 0. And anybody else, anything that doesn't fit in those categories is 15%.
Mm.
Okay.
Yeah, Henry, we don't have that problem as Florida residents,
Yeah.
but this is a great point. A lot of people are Florida residents, but they have property in Pennsylvania or another state. That real property is governed by that jurisdiction. So Stephanie's answer is an eye-opening one for a lot of people. And I think it was particularly brilliant how she pointed out that if you die as a Florida resident with Pennsylvania property that's subject to probate, it is probate times 2, a primary administration open here in Florida and then an ancillary in Pennsylvania. So it can be particularly time and money saving to have that property properly funded into the trust.
Okay,
I will start.
Can I give you a little wrinkle to this whole thing? All right. If you put that real estate into a limited liability company or some sort of other entity, I don't know what it will do in Florida, but it will take it out of Pennsylvania because you die not owning Pennsylvania real estate, but you own a tangible intangible property in a limited partnership interest, which would then make it not subject to Pennsylvania, but subject to Florida tax, which is non-existent, so you would get around it. You would have a real estate transfer tax setting up that LLC, but it is one way if you're, for example, if you're sending it to 15% beneficiaries.
Yeah, Henry,
sometimes we look into it.
Henry, I'll have Stephanie give out her contact information before the end of the show. So if you want to speak to her directly about whether you transfer straight to the trust or some sort of LLC entity, like she just suggested, she'll walk you through all those options and the privacy of your own consultation. So I'll have her give out that contact information before we wrap up. Okay.
Great. Thank you, Patrick.
Henry, thank you. Enjoy the rest of your Saturday. Okay.
I will, you too.
All righty. So I'm going to go to a very patient Mike, and then Stephanie, you and I are going to turn our attention to this Kittler e-will case because it's a fascinating case that demonstrates some great points, especially in a post-COVID world, sort of the echoes from some of the COVID laws that were passed. If you have a legal question, this is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, joined by Attorney Stephanie Kalogridis from the Commonwealth of Pennsylvania. In our third installment of our Estate Planning Around the Nation segment today, we are doing the laws of Florida and the laws of the Commonwealth of Pennsylvania. To be part of the show, 877-943-9673. 877-943-9673. And Henry Hanging Up did open up a line, so if you're trying to get through, give us a call now. All right, let's go to a very patient Mike before we talk about the Kittler e-will case out of Pennsylvania. Mike, how can we help you today?
Hey, Patrick. Hope you all doing well today.
Yeah, doing great.
I had a quick question. My wife and I have been married almost 40 years. We've always had one credit card we share, one checking account we share, and we went in to put some money in CDs, thinking that rates are coming up now. You can get almost 5% on your CD now. So we decided to pull it out of savings, put it in there, and it was told to us when we were sitting at the banker's desk that because if something were to happen to me, even though my wife has been on our account, even with 3 banks before that, with the same account number, because it kept merging with different lenders or different named banks, but on this account forever, that if something were to happen to me, they could technically freeze the account and not allow her to have access to those funds, which totally blew my mind thinking that, because I thought that's the whole reason you have a joint account. So, as protection in that case. Does that make sense to you?
Mike, I want us to all put our hands on the radio or whatever radio device we have handy, and we're all going to say a prayer for all the bank employees that love to give unlicensed legal advice, and we'll invoke the deity and the higher power and ask him to intercede on our behalf, because apparently they recognize not in Florida that giving unlicensed legal advice is still a felony. And so no is the answer. If it's a joint account, especially a joint account between husbands and wives, it's called tenants by the entireties: time, title, interest, possession, marriage. All 5 unities are present. Not only is there a right of survivorship, there's also a creditor protection status. So at the end of the day, I don't know what they were telling you. If it was a joint account between spouses, I mean, let's say you're not spouses. Let's say it's you and a brother who own the account. In Florida, under the banking code, there's a presumption, unless your will or trust or some sort of testamentary vehicle calls out that account, there's a presumption under the banking code that you intended for the surviving owner to get that account. So the idea of it being frozen because of that, that doesn't make any sense.
Yeah, so it's just implied that that remaining partner on that account, has access to it.
Well, I'm going to let Stephanie give the PA answer in just a second, but I do have to ask. Don't say the name of the bank. But was this
Wells Fargo?
No, I'm not.
What's the name of the bank?
You're a terrible listener, Mike. All right. So at the end of the day, I just think it's a matter. Was it a newer bank employee?
No, she was sort of the one that handles, of course, we put monies into the CD from the savings account, and she, I want to say, been there with the company, but moved from another branch, but been with them like 10 years.
And this happens from time to time, Mike, and please don't take this the wrong way. I have clients who have meetings with me and then leave hearing something completely different than what I said. So it is entirely possible that she said something that you took a different way. And yeah, I don't know. I mean, if you talk to her and she wants to reach out directly to me, I'm happy to have that conversation directly with her and hear her position. I'll advocate for my position. She can advocate for hers. And if nothing else, one of the two of us is going to walk away better educated, and there's no harm in that. And I'm, like I said, I do it for free, just in the spirit of helpfulness. But, and I was kind of kidding about the unauthorized legal advice, obviously, because bank employees are just trying to be helpful, but sometimes they do give bad advice. And you did the right thing, Mike. Always bring it to a licensed attorney, and they will always be happy to give you good legal advice on that. But yeah, a joint account between husband and wife, I don't see how it could be frozen. If it's owned as a husband and wife, that doesn't make any sense to me. So Stephanie,
they kept implying.
Go ahead.
They kept saying that she needed to start make her own account. That she needs to have her own account. Because the side B to that is if I get work and I get a work check, and if she goes down there and wants to deposit the check, but then keep $20 out of it, they won't let her do it. Even though she's joined on the account, they said you have to deposit it and then write out a check to take out the money, because you're not named as the person. Although you have endorsed the check over to her, that's the other thing. And we had one of the bank employees was sort of snarky, and she would always say it's Michael's account and that kind of thing. Like it's you're not on this account.
Listen,
but
bank
goes,
employees,
aren't I on that account?
No, bank employees don't get snarky. Okay, that does not happen.
Oh, okay. Right. Okay, you're right. That was kind of my bad.
I'm sorry you had that experience, Mike. I really am. And I really think that it's just a matter of miscommunication. I really do. And I think that, do you have an attorney, Mike?
I have a prepaid legal that I've had for 25, maybe 35 years now.
Okay.
That
Is
I
it,
just pay.
it-
So if I have a question, I can.
then reach out to one of them, one of your prepaid legal attorneys, and try to set up a meeting with, this particular banker and just have that conversation. And like I said, I think that just a little communication is going to go a long way here. And I think there's just a misunderstanding. I think it's a solvable problem. But Stephanie, what's your answer from Pennsylvania's perspective?
Pennsylvania Multi-Party Bank Code says that it's surviving individuals. What they may make you do is open up a new bank account, change the account number and transfer, but that takes hours. It doesn't take.
And they're not going to freeze it.
And they're not going to freeze it. The only thing Pennsylvania does, again, because we do have an inheritance tax, is that we have an onus on the bank to send a notice to the Department of Revenue that says, Joe Smith died and we had this joint bank account and here's the name and the address of the surviving owner. And they send out a notice and they say, okay, well, we're just going to assume that you're a 15% owner, beneficiary. And they quote, they assess a tax and you write back and you say, no, I'm the spouse, no tax due, and you ship it back in and that's the end of it. So our banks have a duty to notify the Department of Revenue so that they can collect their tax. But the account isn't frozen. The money goes directly, immediately. You need a death certificate. That's all you need. And
oh, wow. That's awesome.
Yeah.
So, Mike, hopefully that helps. And we appreciate you calling in, Mike.
Hey, do you mind if I ask one more trust question?
Yeah, fire away.
Okay, so we had two homes. We sold our home, but it was initially written, they had went ahead and did whatever with the deed for the trust. Do I have to, so that's one question. Do I have to do anything special about that? Or does it only, the other thing I was told is that we didn't have to record our present primary residence in the trust until one of us pass away. But then the banker again said, no, you should do that now. And that should be you should be recorded down at the, wherever, property appraiser's office or wherever we have to do that. What's your thinking on those issues?
So yeah, I think that eventually it does need to be recorded. I think it's a mistake to say it has to be recorded immediately because under our statute, signed deed, sealed by a notary, delivered to the trustees, an effective document. I think recording right away is fine if you want to do it, but it also gives up the privacy of the trust. So I think it is a fine line reading of that statute. You can leave it unrecorded and have a successor trustee recorded upon your passing. That has some risk. I mean, if it got lost or something like that, but it does preserve the privacy of the trust the entire duration of your lifetime. It's off the public record. That's a client druthers situation. And I think the important thing for the attorney to do is to make sure the client knows there is a choice there. And I think that would be the important thing to do there, Mike. But if it's been a few years since you've done that, get with your attorney and do a review of the documents. Certainly if it's been more than 3 years, I think it's worth sitting down and going over those questions and seeing what, if anything, needs to be updated, not only in light of the changes in real estate that you've purchased, but also some changes in the law that might have affected your documents.
So the property that's sold that I never did record have it recorded in the proper area or whatever county, I don't have to worry about that.
Well, without seeing the deed, I'm not sure because at the end of the day, it sounds like it's unrecorded. So probably it was a quitclaim deed. And so now the quitclaim deed would be legally ineffective because you've sold your interest. So the quitclaim deed doesn't say you have any interest. It just says whatever interest you have is in your trust. Well, now your interest is zero. So it's sort of a moot point.
Okay, perfect.
All righty. Thanks, Mike.
Thanks, Pat.
Have a great day. All righty. Quickly, Stephanie, let's talk about this Kittler case because e-wills, with COVID, Florida passed some statutes about e-signing of wills, but then made the bar so high to actually use it that it's really just not practical in the state of Florida. But this is your area. So I'm going to let you sort of run through the facts and then talk about the challenges that the e-will case of Kittler poses in a post-COVID world.
So the Kittler situation was height of COVID. The mother doesn't give her age, but she was hospitalized, got a cancer diagnosis, and was in a nursing home. So, during that time, nursing homes were locked down. You couldn't get in, you couldn't get out, you couldn't do anything. So her kids came, her two sons and a daughter-in-law go to the lawyer's office and say, we need mom to do a new will. And this is what we wanted to say. So the lawyer very properly then had a meeting, I don't know, a Zoom meeting, a phone call that doesn't say, had a meeting with the client, established that is indeed what she wanted, and proceeds to draft the document for her to sign. But so in that situation, the signing, the mother was in the nursing home. The attorney and two witnesses were at the law firm, and the notary was at their own home. And they had a conference. They used Doc Verified as their platform. And the lawyer, I imagine, sends out the will electronically to the mother, and she, quote, signs it electronically in front of the witnesses and the notary. And everybody does it. There was a statute that allowed for remote notarization. And that's the way they proceed. Well, fast forward another year, mom passes away, and the family takes this electronically signed deed to the Register of Wills to have it probated. The Register of Wills says, no, this is not valid because mom did not sign it. And they took an appeal from the Register of Wills, and the court says, no, our statute is very clear. You can notarize remotely, but you cannot sign a will. We were allowed to sign real estate documents remotely. There was procedures for that as well, deeds and things and the like. But it specifically did not include wills. If I remember correctly, the legislative intent and discussions, they talked about should wills be allowed, and it was decided that no. So if we take this whole thing, so the family was without it, the disposition was normal. It was to my two sons equally, the same thing that you would have gotten if she didn't have a will. The only thing that I think that she may have gotten was a choice of one son or a third party as the executor. So the court says, we're not legislating. This is a legislative matter. We're not legislating from the bench. The will is not valid. Now, I look back at it and I said, well, why did they proceed this way, right? Pennsylvania. And this is where, because I faced these same exact issues in my practice at that time. Pennsylvania says all you need is it for it to be signed. The lawyer could have taken his will, drafted it after being, comfortable that this is her intent, drafted it, mailed it to her. It may have taken 2 months to go 2 miles, but that's a whole nother issue. But get the paper to her or send it electronically and have somebody print it out if they were doing that, and let her sign it, period. If you want to add some oomph to it, video chat and watch her sign it to make sure she's signing the thing that you sent her.
Exactly.
And she can put it in her nightstand.
Yeah.
Because in Pennsylvania, all we need is testamentary, capacity and things too, but the document has to show a testamentary disposition. So when I die, and signed at the end.
Yeah.
So he could have had a valid will. Now, what would that have meant? Well, that means she dies, the sons go to court, take the document to the probate office, and they admit it, and they say, oh, well, we need 2 people that'll swear that this is her signature. Okay, well, the sons know their mother's signature. The daughter-in-law knows the mother's signature. The lawyer could have signed it because the lawyer saw her sign it and is comfortable that what's being presented is that document that he had mailed her and watched her on the video signing it. Because there's no requirement for that in person in front of the Register of Wills signature of this is a proper document.
Yeah.
So they could have gotten around it so much easier.
Yeah. So
I don't know.
hindsight being 2020, I mean, it's a fantastic point. Stephanie, we're coming up on the end of the show. So to make sure, I know it goes fast, to make sure I get it in, please give out all your contact information for any of our Pennsylvania listeners who want to reach out to you. Like the gentleman we had earlier from Henry from Port Charlotte, I believe, is going to be reaching out. So just go ahead and give out all your contact information.
Sure. I can be reached by phone. It's 610-701-4433, and that's my direct dial. If I'm not available, we'll kick over to my paralegal, Michelle, and she can take your information for you, and we'll get back to you right away. My email address, this is a long one, so it's S as in Stephanie, Kalogridis, K-A-L-O-G-R-E-D as in David, I, S as in Sam, at, and this is a law firm name, it's Lamb, like Baba Black Sheep, L-A-M-B, Mackerlane, M-C-E-R-L-A-N-E
Well, Stephanie, thank you so much for being part of the show today. Miguel, will hold on the line. I'm going to talk to you guys off the air. I appreciate your patience, and I am going to answer your questions. It's just going to have to be off the air. To reach me at my office, 877-754-6764. For any of those who did not get Stephanie's information, I'll be happy to provide it to you. 877-754-6764 to book your complimentary estate planning consultation with me, Attorney Patrick Smith. This is the Attorney Patrick Smith Show. We've had up for our hour our guest, Attorney Stephanie Kalogridis from the Commonwealth of Pennsylvania. Again, Stephanie, thank you so much, and we have to have you back on the show for a future date.
Sounds like a great idea.
All righty, everybody.
Thank you for having me, Patrick.
Absolutely. Have a great day, Stephanie. Everybody, God bless, stay safe, and go Gators.